Good evening, everyone. I am Harsh Anmol, the student convener of Center for Legal Aid program. I am your host for today. On behalf of the Center for Legal Aid program and Pro Bono India, I welcome the resource person, Dr. Hardik Parikh, along with the faculty conveners of CLAP, other members of the organizing committee, and all the participants to the fourth day of the short-term course on legal aid and allied laws. Last day, we had a session with Professor M.R.K. Prasad from V.M. Salgaonkar College of Law on clinical legal education. Today, for a session on drafting of PIL, we have with us Dr. Hardik Parikh. Sir was assistant professor of law from 2011 to 13 at Nirma University and worked as a visiting faculty for law in various colleges of Ahmedabad from 2008 to 2011. He secured university first rank in first year LLB and was awarded gold medal by the Gujarat University and has also been nominated as a member in the committee for evolving the IPR policy for Central University of Gujarat. Presently, Dr. Parikh is an assistant professor of law and faculty convener of Legal Services Committee, ProBono Club, at the Gujarat National Law University, situated in Gandhinagar. Welcome, sir.
Yeah, good evening. Am I audible?
Yes, sir, you're audible.
Kalpesh sir, am I audible? Am I audible, Kalpesh sir?
Yes. You're audible. Yeah.
Oh, yeah. Kalpesh sir, am I audible to you? I cannot listen anything from your end.
Yes. You're audible. Yes.
Okay, perfect. Thank you so much. Yeah, so thank you so much, sir, for generous introduction. And I'm sorry for joining a little bit late. I'm sharing my screen and I hope it's visible. Once it is clear, you just let me know.
Yes, sir, it's visible.
Right? Yes. Visible, right? Okay. Thank you so much. Yeah. Fine. So, Kalpesh sir, two things I want to confirm before we proceed. Class on PIL is already taken place earlier, right?
No. They don't
Okay,
know.
it is the first session on PIL because we are discussing drafting, so we'll not go into technical details of PIL. We will discuss about drafting, but generally it happens that already the students or participants who are in a particular session are introduced. So this is the first session about PIL in this course, right? Okay. Right. Great. Okay. So welcome to everyone. We are discussing one of the most interesting and important topic for public interest litigation. I guess that participants are coming from a different background. They would be students, they would be professionals, they would be also faculty members, and also some of them may be from non-law background who are interested to know something about law, something about social justice, and some of the important aspect about the existing legislation which is frequently used by society. But anyway, as the formal education on law may not be given, I think they would be here. So it's a tough task for us because generally the topic like public interest litigation, which we consider as a very common as well as very super technical subject, it's a combination of both. Common topic means every day in a news, I am sure all of us would be getting some any updates about the public interest litigation, right? Correct me if I'm wrong, that you might be listening to some of the news items, maybe by the electronic media or in a print media, you might be reading that one advocate or one particular group of people or one NGO or any social justice relating institution have approached either any high court or any Supreme Court of India by virtue of the public interest litigation. And then today, public interest litigations are filed in high courts, in Supreme Court of India, and it is immediately catching the attention of the people. Let me tell you that we are in an era where every day some new important news about the law or any notification about change or proposed change in any legislation is very frequently coming. The newspapers and social media and blogs and electronic media is flooded with the legal relating aspects, legal news, and some of the updates are coming every day. We are always wondering that, okay, what is the background of that? And for that, our curiosity would be helping us, that we would be going for on Google search, we would be going to library to read some of the background, and then we would be trying to argue, we would be trying to take a stand, etc. Now, in this case, public interest litigations are very, very popular in recent past. I'm sure you might have heard about the public interest litigation against demonetization, which was in a Supreme Court of India. You might have heard about public interest litigation, series of public interest litigation during the COVID time when people were suffering trauma, the hospitals unavailability, beds unavailability, ventilators, masks, the vaccines. Many things are there, and every day in a newspaper you would be reading something about the public interest litigation. Now, in this question, in this era where the subject matter of the public interest litigation is affecting to all of us, doesn't matter whether we are from the law background or non-law background, the subject matter is always affecting to all of us. Right? Doesn't matter. It's talking about pollution. It may be talking about the financial aspect. It may be talking about the government functioning or etc. But because it is part of the law practice, we might not be aware that actually what is the situation, why public interest litigation is filed. And as Dr. Kalpesh Kumar Gupta has given a very tough task to me, because generally I teach to the law students in a Gujarat National Law University, and when they have subject drafting, there is a drafting, pleading and conveyancing, which is important for all the law students to learn. And then also we have advanced legal drafting subject, which is part 2 of the drafting, where a student who is learning about law, and before they start practicing, they need to understand about drafting of every petition. Also, they need to understand about agreement drafting. They need to understand about the judgment drafting, legislative drafting, etc. So for them and for also the drafting portion, first your conceptual clarity about the law is must. And I would like to say that understanding law is 10%, and putting law in a proper format before the honorable court is 90% of the legal practice. Let me tell you, I may be an expert on Constitution of India. I may be very excellent in understanding fundamental rights. I may be excellent to understand how Supreme Court works, how Parliament works, how executives work. Everything is maybe very common to me. I may be expert in that. But suppose if any one of you approaches me and ask me that, sir, you are part of the legal services committee, and in our organization there is a problem with respect of drawing of wages, our discrimination is happening, the policy has some issue, so can you help me? And in case I can help you by approaching to the honorable court by drafting a proper writ petition, and if I say no, sorry, I am very much good in theory, but I don't know how to draft public interest litigation, I don't know how to draft writ petition, believe me, my knowledge would be something like certificate which is hanging on the wall only. Practical usage would not be there. And that's what the beauty of the law, that many legislations, many laws which are there in our nation, which are there in our society, are actually having some of the elements how you should approach proper judicial forum by virtue of the proper drafting. We follow multiple principles. We follow principles of natural justice. We follow multiple different kind of guidelines. And believe me, the drafting is such a wonderful subject that all the law students have to learn. Plus, apart from that also, as a common citizen of the nation also, we have to understand about that also. So today we'll try to do a mixed method, because 1 hour time, 1 hour 15-minute time we have. And during that time, we are going to touch a little bit on the public interest litigation also, as well as some of the drafting also. I have brought something interesting for you, some of the rules regulation, as well as some of the actually drafted petition, which I would love to discuss with you with respect of that. So let's go without wasting the time about the topic. Now, I'm sure that this is a very popular pillars of democracy, which all of us would have known about that, right? When we say that India, a country in which we are staying and we are following the Constitution of India, and the Constitution of India is also giving multiple layers of different government organizations. So we say that the pillars of democracy has a legislature as a first step, which is part of the lawmaking body. We have executives, which is at the second layer, which is considered to be the law enforcement body, or executives who are part of the officers who have task that whatever laws have been created at the legislature, we need to execute that. And third level, we are putting judiciary, which is considered to be the institutions or organization when we go and when we seek justice. You might have heard a very popular sentence which is always taught to the law students, that power tends to corrupt and absolute power corrupts absolutely. It's very common or very popular saying, right? And that, what is that? It is meaning that whenever a legislature is there in a power, when executives are there in a power, then it is a very likelihood that the executive actions, legislative actions, or sometimes judicial actions also may result into some of the corrupt practices. Corrupt practice not necessarily with a literal meaning, but with meaning that it may result into injustice. It may result into violation of the rights or some of the particular important powers given to the common citizen. Then who would be coming into question? Who would be approachable? And that's how the role of judiciary is coming, by virtue of the Supreme Court at the top, high courts in the middle, and lower courts at the bottom level, where you are approaching to the forum that this is the injustice happened to us, and that's how I want a particular justice, particular actions or particular result from you. And that's how the pillars of democracy who are there for public is very much important. Now, important point about the public interest litigation is that generally we consider public interest litigations are filed in court of law, and then there is a word public interest available. Now, what is meaning of public interest? No definition is clearly available, but generally we connect that whenever public at large, so the society have so many people from the different background, from different particular aspect, which may be social, which may be economical, and now they are going to suffer some of the common issues, some of the common problem, and then this all thing together we put as a public interest. And that's how we say that whenever any matter of the public at large, the matter which are affecting to public at large, and when you are bringing that matter before the court of law, generally we consider it as a public interest litigation. As I told you that there is no clear definition given in any statute. You must be knowing that there are the statute or legislation which are enacted, and this all statutes are giving some of the definitions. But yes, public interest litigation is considered to be the innovative approach of the Indian judiciary. You always remember Justice P.N. Bhagwati and Justice Krishna Iyer's role is also very active, where the activities, or you can say the initiatives like public interest litigation have been started. So we simply, in simple format, we understand that it is considered to be an act which is interpreted by the judges, that whenever public at large interest is concerned, we would definitely be there into the particular field, and we'll try to render justice in respect of that. In a very, very relaxed or very simple word, I say that public interest litigation is nothing else but a relaxation of the rule of locus standi. Now, what do we mean by locus standi? That's a very important aspect, which along with the judicial activism also. Now, these are the very popular word which in a legal regime we keep using. Locus standi is a particular notion that says that whenever a person has any public particular grievance, or if you are a victim, you are suffering certain problem, then you only can go and file the matter before the court of law, right? Obviously, the advocates are there who are helping the parties when they want to go to the court, when they want to get justice. But the advocates can also appear on behalf of the person who has personal interest with respect of that. And that's a very fair rule. I think in a democratic society, we always appreciate that this rule should be there, because otherwise, if you permit anyone else to go in a court of law on behalf of anyone else, then multiple issues will come, like, becoming a tout for someone, becoming a broker for someone, and many more. And that's why court will first ask that show how you are affected. When you are putting it beyond reasonable doubt, we'll be able to apply the legal principle, and when we help you. But then, is it possible in a country like India, where we have multiple issues, including the ignorance, including the poverty, including the legally illiterate people? We say sometime in a very normal way that we are the country where we have educated illiterate people. Now, what I mean by educated illiterate people, because all education is making us to earn certain bread and butter, right? We are able to get some employment, we are able to get some of the important aspects, or we are able to earn money by virtue of doing some job or services or profession. But this all education is not necessarily helping us that what you should do when you are subject of injustice. Now, that's why we are certain level of illiteracy, even though when we are in a particular area where you are working with the government organization, or we are working in a court of law also. And that's how the people who are not able to render justice this particular notion will not help. And that's why the role of judicial activism is coming. Now, what is judicial activism? That can be a separate discussion which we can take, but you can say us in a simple word, we can understand that when the law is silent on some of the aspects, judiciary has taken that particular initiative that we will not be silently sitting and listening to whatever is happening into the society. We will be able to actively take some action, and we will not wait for the law to come out. And the best example which in a legal regime we understand is a Vishakha versus State of Rajasthan judgment. I am sure many of you might have heard, it would be discussed in later part of the discussion also, that Vishakha, which is considered to be, which is NGO, and then one unfortunate incident happened in Rajasthan when one government worker was subject to sexual exploitation and death, and later on the research took place and it was observed that there is no any direct legislation in our country which is protecting a working woman at the workplace. Rather than it is becoming a vulnerable for a lady when she is getting exploited. And then the matter is brought before the court of law by virtue of the public interest litigation, that sir, you have to take some action here, because here the employers or the people who are already working as a higher position holders are subject matter or are the particular accused, and here lady could not do anything. And then court is giving judgment in that matter that now onwards the protection of certain such ladies should be on the shoulder of the employers. Until the time government is not able to make the law, the guidelines which is given by this judgment shall be prevailing, and all the employers shall have to approach it or shall have to accept it. Later on in 2013, we are getting the Prevention of the Sexual Harassment of the Woman at the Workplace Act, which is very popularly known as a POSH Act. And now all of us, whether working in a schools or studying in a schools or universities or anywhere where women are there, there is a mandatory requirement of creation of the internal complaint committee, and that's how it is implemented. So that's an example of the judicial activism, which is making the judges at the particular position that whatever they are able to observe, and when they think that there is an absence, and because of this absence of law, some injustice is happening, they are able to help them. Now, principle of locus standi has been discussed in many judgments. Like, I will not discuss all the judgments. I will share the presentation with you all, because considering the time, I need to touch the drafting wala portion. So it has been mentioned that principles of locus standi are based on the theory that rights and remedies are correlative, and therefore only a person whose own rights is jeopardy is entitled to seek a remedy. So as I told you, that people whose real lives are rights are getting violated, they are able to go to the court, and then some of the portion from the judgment has been mentioned. But now, in a country like India, as I told you, that we cannot stick to the rule of locus standi strictly because of the many issues which you can see on your screen. We have poverty, we have ignorance, we have lack of legal knowledge, as I told you. Number two is high cost of litigation. I don't know how many of us are lawyer in this particular classroom, but we understand that approaching a lawyer, going to the court, fighting a case, paying the court fees is not a easy task for everyone, because high cost of litigation is also one of them, and this high cost of litigation includes the transportation cost also when you need to go to the high court, more particularly when it is part of the any state and it is available at the capital of the particular state. So that's one of the important aspect where we are not able to give justice to the people who may not be earning that much to afford this entire legal charges. Democratization of the justice, redressal of the public injuries, and avoiding plurality of litigation, and curbing executive access and ensuring responsible government. These all are one of the important reasons which is actually making the court to understand that there should be some of the relaxation, and that's how the entire journey of public interest litigation is started. The roots of public interest litigation is also in a preamble of Indian Constitution when we talk about the justice, and not only justice which is a simple connotation, but we talk about the social justice, economic justice, and political justice also. And this justice is always considered to be done when everyone in the society who is inclusively participating in the entire society feels that whenever any discrimination has happened with them, they got opportunity to be heard. We are not talking about getting result in favor. Opportunity to be heard is very important. Unfortunately, because of many reasons, there is no access of the people who can go and who can put the matter before the court of law. And that's how the social justice, which is part of the Constitution of India, preamble more particularly we can say, is there. And that's how the public interest litigations are happening. So there are the interesting cases which are behind the public interest litigation, like Hussainara Khatun case, which is very popularly known about the inhuman conditions of the prisoners, under trial prisoners. And that's how one concern is there, that what is the right to speedy trial, speedy justice, that whether they should wait in a prison for a longer time when they are under trial prisoners, and when the matter is brought before the court is coming by virtue of the judgment to this matter that no, right to speedy trial is also part of the basic fundamental right, even though it is not expressly mentioned. I will tell you that we understand with the proud that fundamental rights, which is mentioned in part 3 of Indian Constitution, is very crisp and very abstract in nature. When you talk about right to equality, only article 14, 15, 16, 17 and 18 talks about equality. But when you talk about the right to life, when you talk about right to freedom, very few articles are there which are very clearly mentioning about the sum of the component. But then courts have interpreted this all term in a level that right to life does not means only right to live as an animal existence. It is also right to life with dignity. And that's why whatever is required to live with the dignity is also irrevocably and without any clear explanation should be part of the right to life. And that's how right to speedy trial has also been added. You can simply do a work when, in case you are interested to know more, just read open Constitution of India, the book which is having many judgments. Like you can take any book in which judgments are there, like like D.D. Basu's Constitution of India edition you can take, and you just read about Article 21. So many interesting contention and judgments would be printed in which you will get it. Right to life include right to health, right to livelihood, right to privacy. All the things are coming as an interpretation of the court, and believe me, all these judgments are more or less part and parcel of the public interest litigations which have been filed before the court of law by the public spirited person. So that's important aspect which is available. That's a very popular case about the Sunil Batra versus Delhi administration, where a simple letter by virtue of the postcard is written by the inmates of the jail to the Supreme Court of India. And in that it has been highlighted that there are multiple torture, multiple assault by the wardens, by the particular officers into the jail, and without looking to any merits, court is coming to conclusion that no problem when someone is suffering injustice in a jail, and if they are able to write a postcard, we will take a cognizance because we will convert that postcard into public interest litigation, and the orders are passed becoming by virtue of considering it is a violation of the fundamental right. So that's the primitive part. This all the judgments are from the year 1978, 1980, when the public interest litigation jurisprudence was evolving in our nation. We always remember three personalities for public interest litigation. As I told you, Justice P.N. Bhagwati, Justice Krishna Iyer, and not forgetting the role of Advocate Sri M.C. Mehta. Whenever you are learning about public interest litigation, you can see plethora of cases which has been brought before the court of law by Advocate M.C. Mehta. And when the court have accepted the contention, accepted the plea, and wonderful judgments have been passed, important judgments including the Taj Trapezium case, the Ganga pollution case, the employment of the children for hazardous employment, and many more. So these are the judgments which are available by virtue of that. So there are many other cases which time is not permitting us to discuss, but I told you quickly about that. So in short, we can say that what is public interest litigation? It's a particular litigation, particular petition which we are filing before the court in respect of the matter which is affecting the public at large. Now you can pay attention here that there are two places or two institutions where public interest litigation may be filed. Now one is the Supreme Court of India. How you can go to Supreme Court of India? The Constitution of India is always giving us the way, that Article 32, which is right of constitutional remedies. And in part 3 of Indian Constitution, it has been mentioned that whenever any person is willing to go to the Supreme Court of India by virtue of filing a plea that their fundamental rights are violated, any writ petition in form of the habeas corpus or mandamus or certiorari or prohibition or quo warranto can be brought before the court, and court will entertain that particular matter by virtue of the writ. The word writ petition has been mentioned. Now, same thing is also applicable with respect of high courts, where Article 226 of Indian Constitution is giving us the opportunity. We always say that power of the high courts are wider than the Supreme Court of India by virtue of the petitions. I'm sure you are able to understand why wider, because in Supreme Court of India we are able to go only in case when the fundamental right violation is coming into question. but high courts can be approached in respect of the other legal rights also. Now, what is different between other legal rights and fundamental right? As I am not aware about the background of all the participants, I have to discuss some of the points which are very basic. So please excuse me in case some of the experienced participants think it's a very similar or very small matter. But yes, we have experienced that in this course, many new people are also joining who might not have any legal background. And that's why little bit repetition, which is about the basic aspect, is also going to be there. So fundamental rights are given by part 3 and they are very limited. So in case of the fundamental right violation only, you can go to Supreme Court. But when legal right, now what is different when we talk about the rights? Right is something very interesting. Right means interest which is recognized and protected by law. In a very simple manner, if you say that I have right to get protection on my creation, so then you are talking about intellectual property. Now, intellectual property is not part of any fundamental right? It is given by specific legislation, namely a Copyright Act or a Trademark Act or a Patent Act. So some of the rights are in form of the human rights, which is part of the UDHR, which is like a basic right, which is right to, right to health and right to get the dignity, right to get respect, etc., which is very broad sense of the human right. Already we have Protection of the Human Rights Act in 1993, we have enacted. Second category is coming by virtue of the legal rights. Now, which is available by virtue of any law. So when I talk about intellectual property, so when law is created and that law is giving you right, that is becoming your legal right. Third portion is coming as a constitutional right. So constitutional rights are those rights which are given by the Constitution of India, not necessarily by part 3, but then other provisions are also there in Constitution of India, which is creating certain rights to you and then you are able to get it. Fourth category is coming as a fundamental right, which are very limited, and that is available by virtue of the part 3 of Indian Constitution only. So fundamental right, constitutional right, legal right, human right, multiple rights are there. So in case you want to know further, you can always get into details on that by virtue of the wonderful reference material. Right now, the social media and also technology has helped us to have access to the multiple blogs, multiple video lectures, audio lectures, also books also. So you can always take a note and you can study about that further. So High Court can be approached in respect of the fundamental right violation plus other legal right violation also. In both the cases, public interest litigation may be filed. Okay, so these are the two ways by virtue of you can get. As I told you that it is important to understand about the fundamental right and legal right. Little bit thing I have already anticipated that many people would be completely new, and that's why this presentation also includes some of the basic understanding about the fundamental right, like what are the important articles of Indian Constitution which are helping you to get the fundamental right. So you can always see part 3 of Indian Constitution where the multiple 6 categories are available as a fundamental right, like right to equality is a fundamental right, right to freedom, which is available in Article 19, 20, 21, 22 is a fundamental right, rights against exploitation, right to religion, cultural and educational rights, and 6th is right to constitutional remedies. So these are the categories of the fundamental right which you can always identify. Drafting public interest litigation is very important in light of the fundamental rights only. So whenever a person goes before the court of law, the question is asked that how you are able to execute your fundamental rights. So remaining discussion is already made here. You can always take a look of the fundamental rights, how it is available. As I told you that public interest litigation has contribution to generate all these rights which are available on your screen. Again, I will repeat that generally only that person can go to court whose right have been violated, whose fundamental, right, or you can say the problem has been occurred in his life. But in case I am a public spirited person, like I will give a simple example that there was a pollution. Like let's take example of the MC Mehta case only. That Taj Mahal, you must have heard that Taj Mahal, which is considered to be the wonderful monument, and it's a wonderful place for many people. We consider it as an Indian monument, and in Indian culture and heritage is very greatly attached with that. And then for some of the year, it happened that uncontrolled economic activities in form of the industrialization happened around the Taj Mahal. And then because of that, it resulted into acid rain. Because in peripheral area, when industries would be working, they would be constantly emitting the dangerous gas and fumes. Now, whenever in season, when this gas and fume is mixing with the water, it is converted into acid rain, and result is that yellowish color of the Taj Mahal, the entire original beauty, white color beauty, is getting deteriorated. The matter is brought before the court of law, because here you cannot say that, okay, you have to be a successor of the constructor of Taj Mahal and then only your matter will be heard. No, it's not the case. So a public spirited person is going to the court by virtue of MC Mehta's petition, And then it is explained to the court of law that see, our national monument is getting deteriorated. That's a case about the pollution. And imagine that what pollution would be causing to all the people together. And that's why court is understanding that yes, it is very important to maintain it, and order is passed. That's a very popular judgment in form of the Taj trapezium. I am very happy that Dr. Kalpesh Kumar Gupta has already published one particular booklet that is relating to the selected judgments on the public interest litigation. And believe me that all these cases which I am referring are part of that. Just read the judgment of the Taj trapezium, what court has said by virtue of sitting. And when you are a law student also, you enjoy reading the judgment. That immediately court ordered that all the industries should stop their working immediately. Number two, that you should shift immediately. Government has been instructed that you should allot the available places which is away from the Taj trapezium, and then till the time relocation happens, not a single person's salary should be deducted. All the employers should have to take care about the salary of the people, and national monument should be preserved. And that judgment is still today considered as a landmark judgment when law student is trying to understand the powers of the court. Similar situation is about the Ganga pollution. Similar situation is about the Kanpur tanneries, when multiple tanneries are there and they keep omitting the a lot of wastage and water into the river, and then entire bank of river is getting so much polluted. And then court considered that no, environmental pollution is also right to it's dangerous to the life. Right to clean environment is also fundamental right, because you can't expect person to breathe in a polluted situation. So we extend the applicability of Article 21, which is right to life, and we ordered that right to clean environment should come under the preview. We'll entertain the matter and we'll give order. So these are the examples, just 2-3 examples I could give because of the paucity of the time. But believe me that this all example, right to livelihood, Olga Tally's case is very popular when the municipal corporation is taking action against the street vendors and hawkers. And when without listening to them, without giving any adequate space, when they are completely removed, then court is coming that no, right to livelihood is also fundamental right. You have to take care about their alternative place, and accordingly you should make it. Right to education, right to privacy. Already, recently the judgment which is available in Aadhaar case is also very unique judgment recently in just few years back, 3-4 years back. That is also making it the right to privacy is also fundamental right. And in India, when Constitution of India has given us the wonderful right, you cannot simply take the privacy of the people by virtue of making them compulsion that your Aadhaar card and which is made everywhere mandatory. Right to travel abroad, right to speedy trial, right to food, health, free legal aid. These examples are also a result of the public interest litigation which has been filed by a public spirited person in court of law, and how they are going to have a judgment. Now coming to this case, as I told you that Article 32 should be used. This is for specifically non-law students, that whenever you are going to the Supreme Court of India, it has been mentioned that Supreme Court of India can be approached by virtue of the multiple writ petition. Now in a legal regime, writ petitions are important aspect with respect of the court proceedings. So there are ways for habeas corpus. So when a person is missing, when there is whereabout of the person are not there, in order to get the person before the court of law where there is an illegal detention or there is a detention without informing to the people and there is no any whereabouts, then habeas corpus is generally used. Mandamus is a word which are used as a petition which is filed before the particular government body or quasi-judicial or judicial body in order to get any particular order. So generally public interest litigations are becoming part of the mandamus only, where government, judicial, quasi-judicial, all the bodies are coming. While two, prohibition and certiorari are purely considered to be the court or tribunals together. So there should be a judicial, quasi-judicial body who has power to take any decision after certain inquiries. And this is the quasi-judicial function which is performed by the some of them. And in case if this function have resulted into violation of the fundamental right, obviously prohibition and certiorari writ petitions can be used. And quo warranto is a petition when some of the public offices are taken by anyone without having any merit, or when you want to challenge that by what authority you are holding this particular position, then the matter can be go before the court by virtue of the quo warranto, and court can take a cognizance and tell the person to prove that whether they are qualified to hold this public office or not. So these are the 5 broad writ petitions. Already when you are in education, you can learn about them all, but generally mandamus is considered to be the prime important when you are able to understand about the public interest litigation. The last thing, and then I will go for the particular, you can say the practical aspect, that public interest litigation is very significant, very important, as I will give one more example to you, and then you can understand that how it is working. I am basically right now in Ahmedabad, and Ahmedabad, just few years back, there is a newspaper called Sandesh, and in that newspaper, what happened that one fine morning, one news article was published on the very front page, and that article was about GIDC, Gujarat Industrial Development Corporation. So in that area, a lot of industries are there, and just next to that area there is a society, and in that society the entire the ground of the society was filled with a red color water. Now that water came out from the gutter sewage line, and it overflew. So when these people have to walk through that particular water, and then whenever they are walking, they were suffering a severe injury on their legs. And just 2-3 days of walking from this particular chemically prone water make their entire feet in a very horrible situation. And with the photo of their feet, with the photo of the skin injury and skin reaction, that was published in a Sandesh newspaper. This publication happened at 6 o'clock in the morning. And then a question was raised that what government is doing when this kind of polluted water is in a residential area and there is no action. 11 o'clock, a High Court judge took a cognizance, and then it was converted into public interest litigation, and immediately the concerned state government authorities were asked that you remain present at 2 o'clock in court and you just reply us that what actually has happened here and whether any action have been taken here or not. Immediately, within 1 day, entire situation was taken into consideration. The sewage line was repaired, and particularly, yes, it's a suo motu petition taken by court of law, and then it was considered that it's a particular news report, but we consider it as a public interest matter, and that's how it has been available. So that's an example that how suo motu matters are taken by court of law. Suppose court is not taking suo motu matter, there are also examples where any person, now here if this can be required to be converted into public interest litigation, that's also fine, because generally what we discuss in a particular locus standi rule, that there are poor people, there are people who are suffering certain injustice, and then all of them are not able to approach the courts. In India we have very in Hindi we can say sabka matlab kisi ka nahi. Sometime when a public place some nuisance is there, anyone who is passing through that, they say are hame kya chodo jane do. Because of this approach and this attitude, many people are suffering a lot of problem, including political problems as well as social problems, economical problem also. And then any one person on behalf of them goes there and actually filing the matter. And that's why these particular petitions are considered to be the public interest litigation. So concept is very good. And courts of India are also allowing that no problem, in case the people, real victims are not able to come, no problem. You can come on behalf of them. We will entertain your matter and we will try to render justice. So that's an important aspect. But as you know, that whenever there is a good initiative, a bad initiative or bad reaction is also starting. I will give a small example to it. It's a little bit funny, but I am sure you will be able to understand that what is a mindset of the society. There was a particular city, and that city was at the outskirts of the jungle, forest. So every time a lot of snakes were coming from jungle to the city, and they were biting citizens also. So citizens were very furious and frustrated, and they were always blaming government, that government is not anything, corporation is not doing anything. Now corporation cannot catch all the snakes together, and it was not possible for them. So the corporation made a law. The law was that now onwards, any citizen who is catching the snake and coming into the zoo, that person will be rewarded. So they decided, say for example, 100 rupees of price, that in case you are catching the snakes, depositing to the government, you are becoming a good Samaritan, so you are helping the government, will reward you. Now that scheme becomes super duper hit. So now all people who were again earlier complaining started catching snakes, and within a week, all the areas become completely snake free. Now technically problem should be ended here. We should be happy. But then situation become worse later on. Why? Because people wanted reward. And that's how one entire series of the people, brigade of the people became ready. What they did, they went to deep forest. They got the small, female snakes. They nurtured the snakes. They started to, make the particular small eggs, and they started to create a situation where the eggs are there and then eggs are nurtured. And after the snakes are there, small snakes, they started selling. And because of that, it became a business. So now it's become a smuggling of the snakes also. Now see, that's an example that when government is making a law, technically it should be helping the society to get any kind of rid from the problem. But then the law, it become issue, and then government came to know that, oh my God, people are doing. And later on what happened, that even the person who were caretaker of the zoo also found to be selling snacks illegally. That okay, zoo mein se snacks le jao aur paise de jao. So now this is also applicable in respect of the public interest litigation. Why? As I told you, that public interest litigation is very important for getting justice, but some people started using misuse for public interest litigation, for publicity, for private interest, for political rivalry, for any oblique motive. And that is the reason that when there is no direct law for public interest litigation in India, Supreme Court and various high courts came out with the rules that now onwards we will not entertain any matter, because यहाँ पे ध्यान रखने वाली चीज है, which is very important, that courts are over flooded with so many matters. I am sure you might have heard about crores of pending cases. Kalpesh sir, we can share the detail of the National Judicial Data Grid with them. I am sure that Kalpesh sir has done a lot of work. You just visit National Judicial Data Grid. Now that's a wonderful initiative by courts in which they are real time giving you data that how many cases are pending in lower court, Supreme Court, High Court. And believe me, these are all genuine cases. Some of the people have genuinely fall into the custody. Some of the people are not able to get justice from the employer, from the government. Their real locus standi wale cases are pending. Now, why court should entertain public interest litigation where this kind of cases are available? So technically, only those genuine issues should be entertained by court by virtue of the public interest litigation, which is really for the people to get justice and not any oblique. And that's the reason courts have now become very strict. And if you remember, if you remember that some of the petitions are literally thrown away. I'll give a small example and then I'll go for that. In Gujarat, one more interesting issue happened just in 2010. There is a particular institution. नाम आपने शायद सुना होगा. इंस्टीट्यूशन का नाम है पत्नी पीड़ित पुरुषों का एसोसिएशन. That some of the husbands have come together and had created a one body. उसका नाम दिया पत्नी पीड़ित पुरुषों का एसोसिएशन. And literally they file a PIL in court of law. Gujarat High Court में उन्होंने PIL file की. Now what was the contention of the PIL? Contention was, sir, our laws are protecting women in every manner. There is a IPC to protect women. There is a Domestic Violence Act for women. There is a particular Dowry Prohibition Act for women. There are the POSH Act is also there for women. So there are multiple cases and multiple laws which are protecting women everywhere. But what is about protection of the man? Man को कौन protect करेगा? So they went to High Court and they filed literally PIL. आप search कीजिएगा पत्नी पीड़ित पुरुषों का association. You will get the judgment. I have the judgment in case it's required to be, in case you want to read it. I'll share with you. Now, in this case, court took the cognizance and court read the entire PIL. And you can guess what would be the fate of this PIL. क्या हुआ होगा इस PIL में? Anyone has any idea what happened with this PIL? It's very popular case. It was printed in almost all the media of all the nation. Yes, exactly. The PIL was thrown away by court and strict instruction stricture were passed that, see, don't waste our time. Whatever laws have been created by government, they are with certain kind of the example, certain kind of research, and lawmaking is not a task of the court right now. So we cannot compel the government that immediately make a law for men's protection when there are multiple cases where women are subject matter of exploitation. So don't come to us, don't waste our time. And PIL was thrown away with the fine of 1 lakh rupees. Now later on what happened, that the association member did not have that money. So they literally stand with the banners and they collected the fine from the people and they paid the fine. This is one example that some people may also go to court to just identify the issue, which they may be their personal issue or which may be their opinion. And obviously, India, democratic country, opinions are always available. But court's time should not be wasted. And that's why courts have come out with some of the important aspects. So now I am sharing some of the important, you can say, guidelines. So Supreme Court of India has come out with the guidelines about the public interest litigation, how it should be drafted. Gujarat High Court and the other high courts have also come out with the litigation. I will simply show on my screen. You can see here that all the different particular, you can say, yes, rules are available. You can see this is the public interest litigation rules by Supreme Court of India. Supreme Court of India rules Order 38. Rule 12 is talking about the public interest litigation. Proper details are available. Because of the paucity of the time, I am not reading it, but I will share all the things with you together, which you can always carry it forward. Just 1 minute. I think my mistake. I have shut it down. I will just open it again. Just 1 minute. Yeah. So here it has been mentioned that what will be considered to be the public interest litigation and what should be the part of the disclosure. Similarly, in a Delhi High Court, in a Gujarat High Court, rules have been mentioned that what will be considered to be the public interest litigation. First time the law is not clear, but court have come out with the meaning of public interest litigation, like that without limiting the generality of the said expression, it shall mean and include the litigation undertaken for the purpose of redressing genuine, substantive or larger public injury or public grievance, or for enforcing public duty or vindicting public interest, but shall not include a matter involving individual, personal or private grievances of the petitioner or anyone else. So that rule have been made very clear now, and that rule is also going in detail that now whenever you come to the court, what you should mention. So now I will just read a sample, because every high court of this country have come out with the rules and regulation how to file PIL. So I will just give you one example, that now onwards, in case you are willing to file a public interest litigation, what you should disclose into pro forma, which is already available. So your petitioner social standing, professional status and antecedents with respect of the credential of maintaining the public interest litigation, what is a personal interest involved, that you have to mention, whether petitioner has ever faced contempt proceedings or not, that you have to mention very clearly. What is contempt proceedings? I am sure you are aware there is a Contempt of Court Act. So now there is a civil contempt, there is a criminal contempt. What is civil contempt? Civil contempt means a willful disobedience with any rules, regulation, order, judgment, or any direction of the court of law. So court has given direction, you don't follow, it's a contempt, civil contempt. And criminal contempt is something grave, where we try to disrespect or we try to prejudice or we try to create a situation where courts' reputations and courts' administration of justice is coming with a compromise situation. So criminal contempt and civil contempt both are there. That's a separate legislation applicable for contempt of court. There's a Contempt of Court Act 1971. So in case any contempt petition has been faced, that also required to be mentioned. What are the facts? Why in a particular court should take into consideration? Maybe it is based on any news report or which is based on any kind of research you have done, that you have to mention. Any nature of injury which is caused to the person who is petitioner or any public society at large. Or in case any petitioner is organization, you have to file it through the office bearer, how you are able to convince the court that this is applicable to you. The petition is required to have a declaration and then full detail of the sources from which the cost of litigation is happening. You must be knowing that approaching court and when you are public interest litigation can always be filed in individual cases. In a law also, you might have heard about the party in person. You know, you can always argue your matter of your own. You can always go to court when you want to file a matter. But sometimes the Supreme Court of Rules and High Court rules, when you don't know, you always go with the AOR, advocate on record. And in High Court, you always take a help of the counsels who are be senior counsel, who may be advocate who is practicing. In that case, you will also be paying certain amount of fees. You will also be paying certain amount of legal expenditure. So who is actually sponsoring that amount? It should not happen that it is becoming a litigation which is sponsored by anyone else outside. So you are also mentioning the source, that how you are able to manage the cost of the petition, and then what are the awareness, how public interest is involved, and what are the cause and what are the remedies. So this should be contention. Now, without wasting time, I will show you something interesting. In case you can see on my screen, this is the list of actually filed PIL before the court of law. I will just put it. This entire, I am sure the list is visible to you. Sir Kalpesh sir, is visible on my screen.
Yes, yes.
Yes, okay. So there is a public, this all are the actually filed public interest litigation. I will show you one sample public interest litigation, which will be very much helpful to you. Now, this petition, just have a look to the petition, and I will try to read some of the important paragraph to you, and this will give you all ideas that how public interest litigation are. This is filed before the Supreme Court of India, and this is the format which you are following, that it will be considered as a public interest litigation. It will be part of the original jurisdiction. Now, why original jurisdiction? Because it is filed under Article 32. So 32 is talking about the original jurisdiction of Supreme Court. Supreme Court has multiple jurisdiction. It may be appellate jurisdiction also. Okay. So appeal from any order of the High Court, you can go with the appellate jurisdiction. And when Article 32 is giving you any scope to approach, you are going with the original jurisdiction. Now, these are the petitioner and respondent. Mr. Mark, who is son of Mr. Black, who is aged about 23 years, and address, who is a petitioner. And respondent is Union of India through the Home Secretary. Now, please keep in mind that whenever you are filing public interest litigation, it is part of the writ petition. Now, one thing which you all should keep in mind, I'm sure that advocates and law students would be very clearly aware that entire fundamental rights are enforceable against state. That's a wonderful Hindi song, आपने सुना होगा, चिंगारी कोई भड़के तो सावन उसे बुझाए, सावन जो आग लगाए तो कौन बुझाए. I'm sure you might have heard this. लॉ में इसको कन्वर्ट कैसे करेंगे कि if a private individual, private company or private institution is violating any of your right, we all have remedy. We can go to police, we can go to court, and court 100% हमारी बात सुनेगी और उनके सामने order pass करेगी, right? So if I am a private person, I kidnap any one of you, you can go to police and you can lodge a complaint. Police will take action, they will find me, and then they will try to release you. But if I am a police officer, I am a state, and if I keep you in my custody, which police officer will take cognizance? जैसे ही आप किसी और पुलिस स्टेशन में कंप्लेन करने गए, पुलिस बोलेंगे हाँ पुलिस ने उठाया तो ठीक उठाया होगा, है ना? They would have something, so don't come to us. So this is the example where individual, private individual, if they violate your rights, you have state mechanism with whom you can go and complain. But if state itself does something wrong with you, you can't go anywhere else, because state will say, suppose example, I take charge of your property, you will go and you can file a case in a court of law, you can go to police station, and police station will definitely ask me why you have taken his property. But if I am a state and I acquire your land, where you will go? Because I have a right, I say I am elected body, I am a chief minister, I have right, I can acquire your land. In this case, these writ petitions are helping us, and that's why all fundamental rights are enforceable against state. So whenever you draft the public interest litigation or any writ petition, petitioners are always individual, but respondents are always state government. They may be Union of India as a central government, or they may be any ministry, they may be police officer, or they may be state government. That's very common thing you have to keep in mind. I hope you are getting. लेकिन अगर आप प्लेन सिविल सूट फाइल करते हैं तो पिटिशनर एंड रिस्पोंडेंट दोनों इंडिविजुअल हो सकते हैं. अगर आप कोई क्रिमिनल कंप्लेन फाइल करते हैं तो then petitioner is also individual and opponent or accused is also individual, because this is the dispute between both of them. ये ड्राफ्टिंग के लिए समझने वाली छोटी छोटी बातें हैं जो आप समझ सकते हो. So here in public interest litigation, opponent is always a state government. State government means they are Union of India, or they are state government, or they are ministers. But you cannot write a name of the prime minister directly, because you are not directly serving the summons to them. We have constitutional privileges, we have constitutional executive positions. So governor, prime minister, chief minister, their name individually you are not writing. You are writing state of Gujarat, state of Maharashtra, state of Rajasthan, and the principal secretary, home secretary, or concerned secretaries are there who will be getting summons on behalf of that particular body. So this is what you are writing. So Union of India, you are writing home secretary, cabinet secretariat. So you are writing address where court will issue summons to the opponent. Similarly, you have written Ministry of Health and Family Welfare, because the contention or subject matter jo petition mein, it's applicable to them. Now see, a writ petition, which is part of the public interest litigation under Article 32 of the Indian Constitution, for issuance of the writ in nature of the mandamus, appropriate order or direction directing the respondent to issue advisory or guidelines for local or civic agencies for proper handling and disposal of the used face masks being discharged as a household garbage, and run awareness program to propagate the correct way of disposing the use of the face mask by the public in order to prevent the release of the COVID-19 through the community transmission. This is the petition which was filed when COVID was at extreme peak point. We all know, we all started using masks, we all started using kit and all the apparatus. But when the masks are thrown away, they are also becoming community transmitter way. There is no guideline by government because it happened first time. So as I told you, during COVID, multiple petitions have been filed because government could not do. They were very busy with the arrangement of the hospital, arrangement of the local requirement, and many more things. And that's why this matter could not be highlighted. Finally, one public spirited person approached the court and asked, sir, it's a public spirited matter. I cannot say I am only a victim of this issue, but there are many people at large. And if you don't advise or if you don't tell government to come out with the advisory, situation will be horrible. India would be a situation where multiple community transmission will happen. And court entertained, and you see, rest is the history. Court gave so many judgments, court gave so many advisories, and states started working on that. Okay, so this is the example. So any public interest litigation, when we draft, we are writing a subject matter in that way. Now it is always addressed to the court and the Chief Justice of that court. If you are writing in Supreme Court of India, you address to the Honorable Chief Justice of India. And if you are writing or if you are putting in before the State High Court, then you are writing the Chief Justice of particular High Court, right? The humble petition. Now see the para number 1. Very interesting. I am reading some of the para. That the present public interest litigation is being filed by the humble petitioner seeking issuance of the writ, order or direction to the respondent to issue advisory guidelines for proper handling and disposal of the used face mask being discharged as a household garbage throughout the country in order to prevent the relapse of the COVID-19. So it's not the case that he can't do anything. I individually cannot issue any direction or order. Who will listen to me? No one will listen to me, because whenever I'll go and explain, the people say, who are you? Because then we are not concerned with some of the matter. So you want courts to take a cognizance. Number 2, what is the credential? So you are writing that you are a law student. Let me tell you, all law students who are here in the classroom, believe me, you can do a lot of differences, because in India, the history is there that many petitions are filed by the law student and court have granted wonderful orders. Shreya Singhal case is one of the example, which is part of the section 66A of the Information Technology Act. You must be knowing Shreya Singhal versus Union of India judgment, where a law student is filing to Supreme Court of India that, sir, what is this? In a democratic country, person is arrested and person is simply exploited just because of putting comment on Facebook. What is this? And Supreme Court took a cognizance, repealed the entire section 66A of the Information Technology Act. So there are a lot of contribution by the law students also. This is one of the example. That's why it has been shared here. That the present writ petition is being filed praying for certain directions which will be very helpful to the citizen at large and will help reduce the risk of community transmission. If such direction are not passed, there is a high probability that COVID cases will be there. So I'm not reading all the point, but I will tell you that whenever you are drafting the public interest litigation, first thing you are mentioning, who are you, how you are getting the cost of public interest litigation. Then many important point is that how the contention or problem you are putting before the court is a public spirited problem. I have a couple of more public interest litigation which I will share with you, that it is question of the environment pollution. It's a question of the traffic on the road. It may be question. I show you the entire list. See, I will quickly tell you that there is a public interest litigation for implementation of the Law Commission report. You might have heard Mr. Ashwini Upadhyay name. He has filed this petition. I will share with you that Law Commission report was there about the hate speech. Government didn't implement. You approach the court and you tell the government ko wo log inko implement karwaye. Then disabled friendly food lane. You must have seen that now disabled people are having a specially able people. We call it SAP. So when a person is not able to walk properly, whether our government buildings and footpath are sufficient for them or not. And for that, this petition has been filed. I will share, you read it and you will get wonderful idea. Public interest litigation for live streaming. The Rohingya refugees were there. And then you must have interest. This is interesting to understand that when you read fundamental rights, some of the fundamental rights are for citizen, but some of the fundamental rights have the word person. Now, citizen and person have different. If you read for freedom, Article 19, citizen word has been used. But when you read Article 14, when you read Article 21, it has been used the person. Article 14, states shall not deny any person equality before law, equal protection of law. Article 21, no person shall be deprived of his life and liberty except according to procedure established by law. Now, what do you mean by person? Person is citizen, non-citizen, both. And that's why Rohingya refugees who may not be citizen of India, but they are person, and that's why right to life is also applicable to them. You should do something. For that, this petition has been filed. This is available. I will share this with you also. Then there are cases of the targeted mob lynching. There are cases, recent past has happened, that public will take a law and order in their hand. They will beat the people and the person will die. This is absolutely brutal because it's not applicable to the democratic nation like that. We have entire state machinery. So in order to stop this kind of lynching, petition has been filed. and there are firecrackers. Multiple petitions have been filed. I wish that I will share with you all because it's not possible to read all. So you are always mentioning that here, that how the contention which you are putting before the court of law is actually applicable to people. And then there are factual aspect. You read all the facts together, step by step, chronologically. I'll tell you one more thing. You will also listen to the classes of the RTI. Let me tell you, RTI is a step 1. Public interest litigation is step 2. Suppose I want to go to court and I want to file a public interest litigation, but the basic data I will collect through RTI. So now onwards in, I think, next module, Right to Information Act, you will study. So what, suppose I am a public spirited person, but I will file RTI before the government authorities. I will get a response, and that response will make me understand that, see, this is the area where government has done nothing. And later on, I will go to Supreme Court, I will go to High Court, and will say, sir, this background and the facts of this petition is personally collected by me through RTI. And that's how this petition should be entertained by the court. And that's how RTI is also becoming very helpful. All the journalists and all the people, even law students, file multiple RTIs, and they collect the data and they approach. So you have to mention that what data you are putting and how the data has been collected. Finally, after that, you are making the legal grounds. Grounds means that what is the standing in front of the court. Fine, all the data you are telling is a very layman's term, facts. But how that thing? Now, I would like to read para number 1 here in the petition. Here, the contention is that face mask not properly discarded, not properly destroyed. Right to life is sacrosanct of the fundamental right guaranteed under Article 21 of the Constitution of India. This honorable court is in catena of the judgments has accepted it as the highest of in all fundamental rights. That right to life includes public health, including physical and psychological health. This is the case in which it has been mentioned, because in present emergent situation wherein every effort is being made to contain the spread of the COVID-19 through community transmission, improper handling and disposal of the face masks which are being discharged as a household waste pose a great threat to the relapse of the COVID-19. And because Ministry of the Health, Family Welfare hasn't prescribed any guideline or advisory for local civic agencies for handling and disposal of such biohazard waste, which is currently being discharged from the Indian household on a large scale, because the worker of the civic agencies who collect the household waste operate under a great threat containing the virus which is present on the mask which are being discharged through the household waste. This worker in turn go around the local neighborhood collecting the waste and sanitizing household, and therefore pose a great threat of community transmission. And that's how this is the question of the right to life. So you are putting it, facts connect with the right. And finally, prayer. Now see what prayer this petition has been mentioned. That honorable court may be most graciously pleased to, number 1, issue writ of mandamus or other appropriate writ, order or direction to the respondent to issue any advisory, guideline, standard operating procedure for local civic agency for proper handling and disposal of the face masks which are being disposed from the household as a domestic waste. And number 2, run awareness campaign through mass media and propagate the correct way of disposal of used face mask, which actually government did. I'm sure you might have heard that there were advertisement on radio, advertisement on television. They come out that whenever the person is coming to collect the mask, don't put it in the normal garbage, put it separately, destroy it in a proper way. So this guideline happen, and this kind of petitions are becoming something based on that. So this is example of the one petition. There are multiple interesting petitions which I intend to share with you. But as it is not a class of the entire public interest litigation, because time is also constrained, and you all are great learners who have thirst to learn something new, and you are standing here for last 1.5 hours. So I think I will stop the discussion here. And in case you have any query, question, you can ask. And Kalpesh sir, some of the references I shared with you, some of the point I will share with you. And in case you think that there is a scope for further discussion, definitely I would love to interact with the students, because generally I believe that a legal knowledgeable person can create a wonderful democratic system in the nation, which is the need of the hour. So all of them are soldiers of justice, and they would learn more and more. And I am sure that they would be able to implement these particular things together, right? So I'm stopping the sharing here, and I would wait for any question, query, try to discuss. I'll try to answer in best possible way. Thank you so much. I think I'm sorry, I saw many hands which were raised in between, but as we were in flow, I could not take their particular question. So Kalpesh sir, in case some of the people who raised the hand can be given opportunity to put their question, and we can entertain one or two in case,
Okay.
if possible.
Harsha, what did you? You raised your hand, Harsha.
Sir, I hope
Participant, you can raise your hand.
yes,
Harsha,
sir.
what
Yes,
do
sir.
you?
Sir, very good evening, sir. Yeah, it was a very insightful session. Sir,
Good evening. Good evening.
yes, sir. Yeah, thank you very much, sir. It was a very insightful session. I had a few questions to be addressed. Sir,
Yes, please, please.
primarily, can a PIL be filed wherein there's a river which has been polluted from many years, and then now we would like the state government to revive it? But will there not be a question that the court will ask that this can be in the form of mandamus? Please file a writ petition instead of a PIL.
Yeah, you are right. See, yes, yes.
Yes,
Yeah,
yes,
any
sir.
question? You
Yeah,
continue,
yeah.
please.
Second question is, can there be PIL filed for the municipal corporations to work on the footpaths, wherein the footpaths are in very bad condition, and we would like this corporations to act upon it? Yes, sir.
Yes, yes, exactly. I'll tell you. Both questions or both the issues are exactly subject matter of the public interest litigation. Only one thing you have to keep in mind. I could not show you the paras. In PIL, you are also mentioning that what actions have been taken earlier, what litigation have been filed earlier. So your PIL should be recent one, that in case previously litigations have been done, previous orders of the court have been filed, but it is not implemented, then you can also include that portion here also. So suppose if the river is a requirement for the particular state and if government has failed to take action, yes, the petition can be filed. Public interest litigation is the best option, it can be done. Separate writ petition can be filed, but then ultimately it will not serve the purpose, because writ petition also have to have a locus standi rule. And when river, found mountains, forests, this kind of public properties are concerned, then public interest litigation is the best example. Number two, when you talk about the footpath, when they are in not a proper situation, now onwards, government has already, court have already passed direction earlier, and now always government has created a one particular initiative where you can always put your complaint. So in PIL, court may ask you that why you have come to us, whether you have approached the proper forum earlier or not. So best option is that when it is possible to be approached to the local bodies in order to control the situation, it's a best option. You should go there, you should try that first. In case they fail horribly to take care, then the same thing can be part of the PIL, and you can say that so many times we have approached, these are the evidences, but as nothing has been done, we want intervention of the court, and then court will definitely entertain the petitions.
Okay, we'll take more couple of questions because we're running short of time.
Sir, there is one
Manjunath,
interesting question. Hariom Tiwari has mentioned international convention. Hariom, this is wonderful, interesting point. I'll tell you. International conventions and implementation of the international convention is a purely policy matter. Because of this positive time, I could not identify you. The way judicial activism is there, there are two more components which we call judicial review and judicial self-restraint. Now, yes, there can be international convention, but implementing international convention are not directly applicable to India. You know, there is a mechanism called ratification. So international convention, India become a signatory, India signs it, and then it is required to be ratified by India. Once it is ratified, but if the law is not properly mentioned, then you can go to court and court can pass a direction. Otherwise, court cannot directly say, because in the policy decisions, when international convention are something for a sensitive issue, and then if court says, no, this issue may create a social disorder, so in that case, court can reject the PIL also. Yeah, there is one question, public interest individual. No, PIL can never be filed before the individual. Individual will not, court will not entertain this PIL at all. Court will say, have you approached the local authority? Individuals can be a party. Say, for example, hospitals which are not implementing some of the guidelines, they can make a party in a PIL, because there are state government and medical, health ministry is also party. So direct individual, not subject matter of the PIL, writ petition or PIL cannot be filed. Court will always say, come through proper channel, and you have to exhaust all the existing remedy first. Because as I told you, court is already overburdened with multiple petition. And there's a very important rule. Like I tell you, suppose I have a fever, I have some small issue, I will not be able to go directly in operation theater. Court will say, the rule is you have to stand in a queue, you have to wait, you have to get a case paper, then sit outside the dispensary, wait for your turn, and then you go to doctor. But if someone has accident on the road, no case paper, directly 108 ambulance will bring him, that person, before the court, before the operation theater. Public interest litigation and fundamental right is something like this, that you can't wait for a normal courts. You have to directly go to Supreme Court, and that's a fundamental right. So courts are entertaining only in case of the grave emergency. So this question can definitely be asked to you, that why in a private individual you have not go to local body, you go there and then you come. So this question, I think they may answer like this. Yes.
Okay, we will take up last question because we are running short of time. Manjunath, over to you. Manjunath,
Good evening. I am Manjunath from Hyderabad.
please speak louder.
Hello.
Sir, there is a question by Mr. Srikant. I think it's a wonderful. Yeah, it can be subject matter of the PIL, but first you file RTI. Let wait till RTI session taken by Kalpesh sir. You file RTI. You ask that what is the reason why the work has been stopped, why railway bridge has not been constructed. RTI can be filed before Railway Ministry, local body also. Collect the data, and then you can simply exhaust the existing remedy, and then you can go for PIL. So collecting data is very important. Don't directly go with PIL. Otherwise, you will not have data. There may be genuine reasons of the work stoppage. Sometimes government would have blacklisted that body also. I'll tell you, this has happened in so many places, that some of the companies are blacklisted by government because they did some malpractices. Because of that, if the work has been stopped, so then the court may impose a huge cost on you. That why, without verifying the fact, you are coming to us. So first take RTI and then you go for PIL. Right? Thank you.
Okay, we have to close here. Sorry, we have so many questions are there. So I will share sir's ID. You can reach out to him. Any queries are there, or I think some
Yes,
of
yes,
have
I
been
would
already
love to
covered.
answer for sure, 100%.
Thank you very much. Sir. Harsh, over to you.
Thank you so much, sir, for an informative session. I'm sure the participants enjoyed it. Now, I invite Dr. Shweta Mohan, the faculty co-convener of Center for Legal Aid Program, to deliver the vote of thanks.
A very good evening to one and all. Heartfelt thanks to Dr. Hardik Parikh for being with us today.
Thank you so much.
Sir, it was a privilege for having you as a speaker, and you have been shedding light on such an important aspect of law. PIL is undoubtedly an important tool for safeguarding the fundamental rights, and the key details that you have shared with the help of the case laws were very, very informative. And along with that various case laws, you have also explained how one can get help and how one can get protected through this means of PIL. Thank you, sir, for having such a wonderful session. Thank you so much.
Thank you so much. It's actually my pleasure to have been invited here, and I'm sure that you will definitely keep letting people aware about the legal aspect. And I would love to help in case in future if you want any other session or any other thing together. Thank you so much, sir. Thank you.
Thank you.
Thank you, sir.